A very good evening to one and all who've joined us today for Text in Context with Banana IP November edition. First of all, a very happy Children's Day to one and all. And first up, we have Tanmay, who will be presenting trademarks and copyrights update. Over to you, Tanmay.
Good evening, everyone. My name is Tanmay Purohit, and I am with the Trademarks and Copyrights team. I'll be walking everyone present here through with some of the copyright and trademark updates that have happened in the last month. We'll be dealing with two cases. One of them is the Entrepreneur Media Incorporated versus the Senior Examiner of Trademarks Delhi. This will be related to the trademarks section of this presentation, while the second one, Anil G. Karkanis versus Kirloskar Press, will be concerned with the copyright section of this presentation. For our first case, the case Entrepreneur Media Incorporated versus Registrar of Trademarks, Delhi. This particular case was an appeal filed before the High Court, Delhi, against a decision of the Registrar of Trademarks, Delhi. This particular appeal was filed by Entrepreneur Media Incorporated, who was the appellant in this case. The company, which is based in USA, publishes Entrepreneur magazine, and in India, they began publication in 2019. This particular case concerned one application filed by the company for the mark Entrepreneur in classes 9, 38, and 41. This application was filed in 2016, while at the time, the company had already registered the mark Entrepreneur under class 16 in 2001. Pardon. This particular application in class 9, 38, and 41 was objected to by the registrar under section 11.1. The registrar cited some conflicting marks to this application for the mark Entrepreneur in his examination report. The appellant responded to the objection in the response to the examination report and presented support for their application. Let's take a look at the marks that were cited as conflicting by the registrar. These 4 marks were cited by the registrar as conflicting with the mark of the applicant in this particular application. As you can see, these 4 marks are registered under class 41 for varying class descriptions. Let's call them mark A, B, C, and D for now. We'll deal with them a little bit later. After the examination report response was filed by the appellant, the hearing was scheduled in 2019, where the appellant once again argued for acceptance and presented evidence in favor of their mark. But the registrar refused the mark citing section 11.1 again, and therefore the applicant preferred an appeal before the Delhi High Court following the decision of the registrar. In the appeal before the High Court, the appellant once again submitted the evidence that they had produced before the registrar, that they had already prior registrations obtained in multiple jurisdictions. These jurisdictions include United States of America, Mexico, Canada, and several other countries. However, the registrar had disregarded this material evidence. Also, the fact that the applicant had already claimed prior use in India since 2009 for this particular mark, and that some of the cited marks were inactive, while the others had varying class description for their marks. Let's take a look at the marks once again. For the marks 1 and 2, the appellant argued that the proprietor of the first mark had already given a letter of consent for the use and registration of the mark by the applicant in India. For the second mark, the application had already been withdrawn because the applicant did not wish to pursue this particular mark in India. For the third and fourth, the applicant for the mark Entrepreneur, that is the appellant in this case, argued that they had varying class descriptions and did not conflict with the applicant's mark in the first place, and that there was no likelihood of confusion for both of these marks. The applicant further cited the case Vishnudas Trading Company versus Wazir Sultan Tobacco Company Limited and submitted that a proprietor cannot monopolize the entire class of goods. Following these submissions, the court sought any arguments from the respondents in this regards, but the counsel for the respondent did not contest the matters related to the cited cases at all. Failing any submissions, the court's decision said that the respondent had failed to properly respond to the submissions made by the appellant in this case and remanded the matter back to the registrar. The court further asked the respondent to consider the material evidence that had been submitted by the applicant, that is the prior registrations, the inactive status of the cited marks, and the difference in goods and services under some of the cited marks. Now we'll be moving on to the copyright cases for this section of the presentation. This particular case, Anil G. Karkanis versus Kirloskar Press, was filed as a petition before the Bombay High Court. The petition sought a license to produce and publish the transliteration of the literary work, The Spirit's Pilgrimage, which is a famous literary work authored by Madeline Slade, popularly known as Mirabelle. The work was published in 1960 by Orient Longman Publishers, and the author had passed away in 1982. Since the book was published in 1960, the conditions for the grant of license under Section 32 were satisfied. Section 32 of the Copyright Act lays down 3 requirements for any applicant who seeks license for publication of any literary work or dramatic work. The 3 conditions herein are as follows. First, the work needs to be published in India. Secondly, the publication of the work needs to be 7 years prior to the petition of that license. Thirdly, the petition needs to be filed properly under Form 6. The petitioner submitted before the Bombay High Court that they did attempt to trace the original publishers of the work, but none of them existed at the time of the petition, so they could not contact them for the purpose of seeking a license from them. They also submitted that they were able to find one abridged translation of the work, which was translated by one Mr. Ranga Marathe, who was the translator of the work and published by the respondent number 1 in this case, that is Kirloskar Press. However, the petitioner was unable to find the translator or the respondent number 1 since they did not exist at the time of the petition, and thus the petitioner could not pursue the matter with them. The stated purpose of the translation as submitted by the petitioner was that they did not intend to make any commercial or private use of the translated publication, but this is solely for the public interest since they intended to publish this Marathi translation for the public interest. In response to the submissions made by the petitioner, the court found itself satisfied with the material presented and deemed that a notice under section Rule 33 of the copyright rules was appropriate. They also noted that since none of the original publishers existed at the time, the notice to the owner of the copyright was not deemed necessary. The format for the notice, which was to be published by the Registrar of Copyrights in the journal, was provided by the petitioner itself. The notice stated that any person who would claim any interest in the copyrighted work should come forth with a written application within 120 days of the publication of this notice. However, they will also have to submit adequate evidence to substantiate their claim of the interest in the copyrighted work. Thank you, everyone.
Thank you, Tanmay. Next up, we have Mahashweta, who will be presenting on DS Biopharma Limited versus the Controller of Patents and Designs in another. Over to you, Mahashweta.
Good afternoon, one and all. I'm Mahashweta, presenting on DS Biopharma Limited versus the Controller of Patents and Design in another. The date of decision for this case was 30th of August 2022 in the Court of Justice Pratibha M. Singh, Delhi High Court, and the hearing has been done through hybrid mode. The appellant is Ireland-based company, and they filed their PCT national phase application in India on 10th of November 2017 with application number 2017-170-40270 titled Composition comprising 15-oxo EPA or 15-oxo DGLA and method of making and using it. Initially, the applicant filed the application with claim 1 to 26 with a priority date of 13th May 2015, which got published on 29th December 2017 in Weekly Journal under Section 11A of the Act. Then a request for examination, also known as RFE, under Section 11B of the Act was filed by the applicant on 13th May 2019. The appellant thereafter voluntarily amended the existing claims and introduced new claim 1 to 26. IPO New Delhi issued first examination report FER on 5th March 2020. First examination report had the following objections. Number 1, all the claims 1 to 26 lacked inventive step. Number 2, non-patentability under Section 3I. And number 3, lack of clarity and consciousness under Section 10.5 and 10.4C of the Act. The applicant submitted response to FER on 8th of July 2020, in which the applicant cancelled claim 7 to 26. The IPO New Delhi then issued hearing notice on 25th November 2020, in which it objected non-patentability under Section 3D under the Patents Act for claim 1 and 4 of the application. Now, Section 3D talks about the invention which are not patentable if the mere invention is a new form of known substance or and does not result in enhancement of the known efficacy of the substance, or the mere discovery of any property or new use of known substance, or of the mere use of known process, machine, apparatus, unless it results or employs at least one new reactant. Appellant submitted written statement WS on 28th December 2020, amending its claim with only claim ranging from 1 to 4. After WS was filed, Learned Assistant Controller of Patents rejected the said patent application by the impugned order dated 13th January 21. Now, Ms. Mani, Learned Counselor of Appellant, submits that the appellant satisfied FER objections and new objections were raised in hearing notice under Section 3D. She also submits that the patent application was rejected on the ground of lack of inventive step under Section 21JA, in addition to Section 3D, and lack of clarity under Section 10.4C of the Act. Section 3D bars from patentability of new form of known substance, but the hearing notice never identified any known substance and left it to the appellant's deduction as to what is the known substance. Here, the appellant also referred to Fresinas Kavi's judgment, where Justice Pratibha Sridevan concluded that for the purpose of a Section 3D objection, that the one specific known substance is to be identified, and the manner in which the claim compounds are new forms ought to be mentioned by the Patent Office, even if it is not in detail, but in a brief manner. Now, Learned Controller had failed to identify the known substance in the hearing notice, and therefore the appellant was unable to respond clearly to the objection of the hearing notice, which in turn severely hampered the opportunity of the appellant to defend its patent application. So it was held in the court, in the Delhi High Court, that in the absence of proper identification of known substance in the hearing notice and lack of proper opportunity being offered to respond to the objection under Section 3D, the impugned order is not sustainable. And on top of that, Delhi High Court also said to afford a fair opportunity to the appellant, the following directions were issued. Number 1, the appellant shall file its response on the basis of identified known substance and the extract of the impugned order as set out above. In response, the appellant may also produce efficacy data and support its submission as to how Section 3D is not applicable for their invention. The second direction was the respondent shall file, the response shall be filed by the appellant within a period of 8 weeks, upon which a fresh hearing notice shall be granted on the issue of whether claim 1 to 4 are liable to be granted or not in view of the objection under Section 3D of the Act. Number 3, the controller is also permitted to consider, along with the objection of Section 3D, the objection relating to lack of inventive step, if any. In addition to that, Delhi High Court also perused claim 1 to 4 and said that the objection under Section 10.4C and Section 10.5 of the Act would not arise in the present appeal. And Delhi High Court also gave Learned Counselor only 6 months to decide for the appeal. And the appeal is allowed in the above term. The impugned order is set aside. Nothing stated in the impugned order and in the present order would bind the controller on the merits of the objection, which are to be dealt with him under Section 3D or under Section 21JA of the Act. Thank you.
Thank you, Mahashweta. Next, we have Sushma, who's presenting on patent and design statistics for the month of October. Over to you, Sushma.
Thank you, Kavya. The patent and industrial design statistics for the month of October is presented here in the graph. A total of 5,538 patent applications were published last month, out of which 1,845 accounts for early publication and remaining 3,693 account for ordinary publication. It is notable that Chennai Patent Office has the highest number of early publication and ordinary publication, with 779 early publications and 1,351 ordinary publications. Last month, 3,987 patent applications were examined, out of which 1,611 FERs were issued from Delhi, 726 from Mumbai, 1,385 from Chennai, and 265 FERs were issued from Kolkata jurisdiction. With respect to patent grants, 2,187 patents were granted last month, out of which 826 patent grants happened from Delhi jurisdiction, 356 from Mumbai, 760 from Chennai, and 245 patents were granted from Kolkata jurisdiction. With respect to industrial design registration, a total of 809 designs were registered last month. All the data presented here were collected from 40 to 43rd issue of Indian Patent Office Official Journal. For weekly patent statistics, check out BananaIP's IntelliPedia IP News Center. Thank you.
Thank you, Sushma, for the insights. Next up, we have Soumya, who will be presenting on a recent case titled Dry Air, Procon, SAGL, and others versus Union of India and another. Over to you, Soumya.
Thank you, Kavya. So today I'll talk about a Delhi High Court decision concerning Dry Air, Procon, SAGL, and others versus Union of India and another. A writ petition was filed by the petitioners. The petitioners are a part of Power Group. That is, there are 3 petitioners. So the writ petition challenges the impugned order by the Controller of Patents, whereby patent applications filed by the petitioners were deemed abandoned as well as lapsed due to non-filing of timely response to the first examination report, and also on account of non-filing of the renewal fees. The petitioners had appointed the first patent agent for prosecuting and coordinating these 6 applications and a granted patent before a granted patent which is lapsed before the Indian Patent Office. So basically, the petitioners wanted the first patent agent to periodically report on the status of the pending applications as well as the patents, and also intimate the petitioners if any action was required. These are the patent application numbers in the lapsed patent. So the issue was identified in the case of a national phase application by European associates. So an FER was issued by the Indian Patent Office on March 22nd of 2018. Due to not filing response to the FER within the stipulated time, the application was deemed to be abandoned on April 4, 2019. The European associates working for the petitioners, they happened to check the INPAS website and inform the first patent agent about the abandonment, who in turn took a position that they had not received the FER. Then the European associates, so subsequently the first patent agent informs the European associates that they had sent a formal letter to the Indian Patent Office intimating the non-receipt of the FER and requesting for the reissuance of the same. Subsequently, correspondence was exchanged between the petitioners, the first patent agent, and the foreign associates. And all through, the petitioners were given the impression that the first patent agent was actively pursuing the matter at the Indian Patent Office, and that the delay was due to the ill health of the Indian Patent Office and the limited functioning of the Indian Patent Office on account of the COVID pandemic. The petitioners then get suspicious and decide to transfer the power to prosecute and process the applications and the patent to a new agent in January 2022. And the new agent happens to inquire with the Indian Patent Office if the FERs for the applications were sent to a correct email address, and they were informed by the Indian Patent Office that they were indeed sent to the correct email addresses. Upon confrontation with the first patent agent regarding the negligence in prosecuting the applications and the patent, the first patent agent admits his negligence. And so the petitioner's contentions are that they have a long association with the first patent agent since the year 2012, and they had a reasonable expectation that he would comply with the standing instructions of the petitioners for prosecuting the applications within the stipulated timelines and the deadlines. The petitioners also contended that based on the information given by the first patent agent, they were made to believe that the first patent agent was meticulously following up the matter with the Indian Patent Office, including the steps for restoration of the patent applications and the patent, which was evidently not the case. The petitioners place on record the entire correspondence, which includes letters and emails exchanged between the petitioners, the foreign associates, and the first patent agent. And so the rules and sections relevant to this case are first Rule 138, which talks about the power of the controller of patents to extend time prescribed in the rules for a period of 1 month in certain cases. And one of the exceptions is time for meeting the deadline under Section 21. That is time for filing the response to the office action. So the prescribed time limit is 6 months from the date of the issuance of the FER, with further extension of 3 months. Then the other relevant rule sections are concerning the restoration are Section 53, Section 142, and Section 61. So in summary, when a patent is granted after the expiry of 2 years from the date of filing the patent application, the renewal fee becomes due within 3 months from the date of the grant of the patent and within the extended time period of 6 months. A patent granted in India lapses when the patentee fails to pay the renewal fee within the given time. The patentee can file an application to restore the lapsed patent within 18 months from the date of lapse or cessation. So the issue here is, can abandoned patent applications and lapsed patents be revived or restored, taking into consideration all the rules and sections that I just mentioned? So in this case, the court relies on 2 judgments, European Commission versus Union of India and Ferit Alani versus Union of India. Based on these cases, the court observed that the patent applications were deemed to have been abandoned on account of the negligence of the patent agent in not filing reply to the FER within the stipulated timelines. And the contention of the applicant was that despite continuous follow-up, the patent agent had not responded and the delay was not attributable to the applicant. Also, the petitioner sought continuation of delay in filing reply, contending that valuable rights in the patents had been lost for no fault of the petitioner. The court observed that while exercising writ jurisdiction, the courts have extended the time for filing response to FER in extraordinary situations where patent agents were found to be negligent in prosecuting the patent applications with no contributory negligence of the applicant. and on showing that the applicant had a positive intent to prosecute. The court also observes that abandonment requires a conscious act on the part of the applicant, which would manifest the intention to abandon, and no presumptions can be drawn in this respect. Further, the court observed that deemed abandonment of the application for grant of patent leads to serious impact on the valuable rights of the patent applicant, which flow in favor of an invention. And this is compounded by the fact that under statutory scheme, there is also no appeal provided against order of deemed abandonment under section 21 of the Act. So the court had observed that for each case would require examination on its own facts and circumstances to see the intent of the applicant to abandon. So based on these analysis, the court decides in favor of the petitioners, and the applications for which the FER reply was not filed within the stipulated time, the court orders the applications to be restored to original positions, and the petitions have been allowed to file the response within a period of 4 weeks from the date of the decision. And in the case of the lapsed patent, upon the petitioners filing restoration application within 4 weeks from the date of decision in a prescribed format and also with the payment of prescribed fee, the patent office was directed to consider the revival or restoration of the patent in accordance with the Act and rules. Thank you.
Thank you, Soumya. Next, I'll be taking you through the recent 2022 amendment to the IT rules 2021. So just to give you a brief background, on 21st February 2021, the Ministry of Electronics and Information Technology notified the Information Technology Intermediary Guidelines and Digital Media Ethics Code Rules 2021, which further, it's in addition to the existing IT rules, and it further expanded on various grievance redressal mechanisms, duties and compliances for different types of intermediaries. And this was done so as to get in a sense of accountability from the perspective of the intermediaries. Then recently on 6th June 2022, the ministry notified a draft for certain proposed amendments to the rules and invited comments and suggestions. And on 28th October 2022, the ministry notified the amendment rules after a public consultation. To say in brief, the key changes brought in by the 2022 amendment are as follows. Firstly, there was an establishment of a grievance appellate committee. Second, the disposal of complaint by intermediary for certain situations has been reduced to as less as 72 hours. And the language of communication from the perspective of intermediary to the user has been changed. Then there's certain addition in the duty of intermediary from the perspective of ensuring and safeguarding the constitutional rights of the users. Intermediary is also shouldered with a new obligation to enhance accessibility of its services and platform. The information which is prohibited to be hosted and stored on their platform has been revised. And there's an enhanced obligation on the intermediary towards mandating certain compliances by the user. To see first is the establishment of the GAC. It is a 3-member committee. It comprises of a chairperson and 2 independent members, which will be established by the central government. And this is done to deal with the appeals, which will be from the decisions given by the in-house grievance officer of the respective intermediaries. The appeal must be filed online before the GAC within 30 days from the decision given by the grievance officer. And the GAC is given 30 days time from the date of receipt to resolve any such appeal. They have also given an option of online dispute resolution to resolve these appeals. The next is timeline for disposal of complaint. So the grievance officer has to resolve certain specific types of information and any request for removal of such information received, or for specified content, like a content belonging to someone else, or a content which is infringing someone's trademark, patent, copyright, and so on, within 72 hours from the time of reporting. So earlier it was 15 days, if you can see this table. Now it's been reduced to 72 hours. There's a change in the language of communication as well. So an intermediary is supposed to communicate the rules and regulations, privacy policy, and its user agreement in English or any language specified in the 8th schedule to the Constitution, which is our Indian official languages. So earlier they were just asked to communicate. Now they've specifically added the languages. They've also been given an additional duty to respect the constitutional rights of the users, and it's a statutory obligation to do so. So they have specifically pointed out Article 14, 19, and 21. They have also given an additional duty of enhancing accessibility of its services. So the intermediary is responsible for taking reasonable measures to ensure accessibility of its services to all users, along with reasonable expectations of due diligence, privacy, and transparency. A point to note here is this duty of ensuring accessibility is actually not new, and it's not brought forth just through this amendment. This is already in place from the Rights to Persons with Disabilities Act of 2016, of which section 42 under chapter 5 says that every person must be given access to the information and communication technology in an accessible format. Then there have been certain changes in the types of prohibited information. So the types of prohibited information has been revised to, earlier they had defamatory and libelous content as a criteria, which has been currently removed. And they have included content that is any content that promotes enmity between different groups on the grounds of religion or caste with the intent to incite violence is prohibited. Then intermediary has been mandated from ensuring that user also follows the rules, and they have to ensure the compliance by the user. So the intermediary has to inform, publish the rules and regulations, privacy policy, and user agreement of its services, and also undertake reasonable measures to ensure that the users comply with the same. Thank you. So on this occasion of Children's Day, I would also like to take you through the patent application, which is filed and granted in the favor of the youngest patent holder in India, which is Vishalini. So at the age of 7, she got a patent granted in her favor. And she filed this along with 2 other people, Dr. M. Naresh Kumar and Dr. R. Chitrakala. So the patent is about, the title of the invention is an automatic multifunctional life rescue flood house. So this was granted on 10th May 2021. The abstract for which reads as, the invention relates to a device or system which floats in water and is used to keep one or more person from drowning during floods. The system or the device or system automatically pops up in gear. In an embodiment, the invention is an automatic multifunctional life rescue flood house, which includes 3 regions. The first, the second, and the third region are separated by an air fill or gap, and each region including of 2-layer air survival casing. The first layer and a second layer equipped with gas generating capability, and the surface are coated with flood material and metals to manage heavy load. A cabin encapsulated by the third region of the housing, the cabin having a lower area and an upper area. The lower area of the cabin includes a plurality of seats for the passengers with respective seat belts for the body and for legs. The upper area of the cabin includes a zipper positioned at the center, which is water-resistant paste as a cover and has a functionality to open and close on both the sides to provide access to the cabin for the passengers. Although the status on impasse shows that it's granted, but recently they have been issued an FER, which they're yet to respond. And with that, we come to the end of our text to context session for today. Thank you for joining us